SJC-12088, Commonwealth versus Andrade.
Mr. Aceel, good morning.
Good morning, Your Honor. Good morning, Justices. May it please the Court, this case involves the application of a protocol that it has crafted over the years. The day scenario protocol is what I'll call it. And as the Court is aware, this is an exception to the normal rule that prior inconsistent statements may be admitted, but only for impeachment purposes. Any exception to a normal rule would always call for a deliberate and a measured approach, not the quantum leap that the Commonwealth has attempted in this case. I'd like to begin with my first argument, why directed verdict should be ordered in this case. The facts from 1995 decision of this Court.
I need my chairs falling off. So,
Oh, my goodness.
Yep.
okay. Sorry about that. They say a wardrobe malfunction or the equivalent. Okay. Now I will not fall off my chair as I listen to you. So, okay, you were speaking about the grand jury testimony. And
Yes, Your
its
Honor.
submission.
And I begin with my the first argument. I'd like to focus on why a directed verdict should be ordered in this case. In 1995, this Court noted in Commonwealth v. Judge, the facts suggested in leading questions, which are answered in the negative, are not evidence. In this particular case, the trial court gave an instruction that is uniformly and always given in all civil and criminal cases here in Massachusetts. The court told the jurors in its preliminary instructions, and this is at pages 53 and 54 of Trial Transcript Volume 3, questions to witnesses, no matter how artfully phrased, are not evidence. Only the answers which you receive from the witnesses testifying under oath are evidence. The court later on, at Volume 7 of the trial transcript at page 117, in its final instructions, told the jurors, reminded the jurors, questions put to a witness are never evidence. Only the answers are evidence.
Mr. O'Seal, isn't there another way to look at how how this whole thing transpired, which is the judge said that the grand jury testimony could be offered substantively, right? And you're not quibbling with that?
We're not, Your Honor.
Okay, so the grand jury testimony may be offered substantively, and it's sort of the way that the prosecutor did it is the issue.
That is the issue, Your Honor.
Okay. But had he just read it straight through, that wouldn't have been a problem as far as you're concerned.
That would not have been a problem. In fact, the trial court in this case, when the issue first came up, and this is at pages 49 to 53, when there was a colloquy, a discussion about this, and the issue was first raised by defense counsel, the trial court said, I think there's a difference between questions that are framed, did you tell the grand jury this, or did you tell the grand jury that? And there's a difference between that and reading the testimony into the record. There absolutely is a difference. The first one, no evidence comes in. The second one, the evidence does come in.
But ultimately, didn't the judge say, I think this was adequate?
The judge did say, continued on again at pages 49 to 53, telling trial defense counsel, Mr. Galabois, I think your other arguments have some merit, Mr. Galabois, but I think in a situation like this, the prudent way to proceed is to allow this to go to the jury, and I think if necessary, we can deal with it afterwards. He continued, I think you raise a critical issue. Are the questions put that way properly before the jury? I believe in reading the transcript that they are, but I could be mistaken. We can deal with that. And here we are to deal with it, Your Honor.
Okay. And what's the standard of review that we should look at his decision to allow the information in substantively, the way it came in?
That's an abuse of discretion by the trial court to have permitted it in at the time.
Okay.
But not an abuse of discretion for him to have allowed the statements to come in.
No, we do not, we respectfully suggest, Chief Justice, that the statements did not come in
Right, no, I
the
know
way they
that.
were presented.
But I mean, I guess you're viewing all that he said as essentially a compound question ending in, do you recall that? And the answer essentially being no, and therefore, but one could also view this essentially as him reading in portions of the transcript substantively, and then asking the question, do you recall that? And then the only question is really, do you recall that? And then you would have the substantive grand jury testimony and a question, and you're trying to place them all as one broad question.
And I respectfully suggest that to conflate them in that fashion, Your Honor, runs afoul of the clear rule that and the jurors were told, answers to leading questions that are not, that are answered in the negative, those leading questions, the evidence, or any statements included in those leading questions does not come into evidence unless they're adopted by the witness. And the prosecutor in this particular case did it for 40 pages of testimony, one leading question after another, all of which were said, I don't remember, I don't recall, et cetera, et cetera. That went on for 40 pages, and then in its closing, the prosecutor, basically over 3 days, three pages of transcript closing, argued suggested to the jurors that they had heard from multiple witnesses. They had not heard from multiple witnesses. They had simply heard the prosecutor put all of those leading questions to which none of those three witnesses adopted or agreed with.
Have we ever, I know that we've discussed in McGee and Cenero, and we've said that the prior grand jury testimony may be admitted in evidence for substantive consideration. Have we ever discussed how it should be done?
Not to my knowledge, Your Honor. I found no cases. The trial court at this, in this case also said he had looked for cases at the trial court level and found no cases indicating exactly how the questions should be raised. But the trial court did suggest ways and said that, and this is again at pages 49 to 53, and said that the prosecutor can simply read question, answer to the jurors, and the jurors are instructed that those answers are coming in substantively by way of evidence. Or, as the trial court said, we could do it by way of a document and prepare another exhibit that includes the agreed upon portions of the grand jury testimony that are coming in and submitted as an exhibit. Another way that I would respectfully suggest is bring in another individual to take the witness stand and simply do a Q&A with an individual on the stand simply reading.
But what you say, if you look at all the cases from the beginning of the feigned memory being the functional equivalent of an inconsistent statement and the grand jury testimony being under oath, if you take a look at all those cases, the import of them are the judge makes a preliminary question of fact determination that it's a feigned lack of memory. You make sure the grand jury minutes are not just leading questions.
Right.
And once that old Commonwealth versus Day foundation's been satisfied, then those portions of the grand jury minutes can be put in without commentary.
Exactly. And the jury would be appropriately instructed as to exactly what's happening.
So that they can differentiate between the prior inconsistent statements that were admitted to impeach and those that were admitted substantive.
Right. And at defense counsel at that point would have an opportunity on cross-examination to stand up and has something to actually cross-examine. He couldn't do it in this case. I'd respectfully suggest that what happened in this case is exactly the colloquy that should occur outside the presence of the jury during the voir dire hearing to see if the de scenario standard, if in fact this witness is feigning memory loss. And if in fact that had occurred early on, that 40 pages of testimony was included in the voir dire preliminary determination by the judge when the prosecutor requested it, I don't think there'd be any question of a doubt that the witness was clearly feigning memory loss.
Oh, I thought you said it was fine, that you agreed with the determination that there was feigning.
Right, we're not challenging that at all in this case. I'm saying that the questioning that did come in substantively in front of the jury, that's the kind of questioning that should take place preliminarily at a voir dire hearing, and it didn't. And in fact, as Cenero says, the judge's finding of feigned memory loss, the jury is not supposed to know that. Judge Chen actually said that in this case.
Well, the concern is this.
I'm sorry, but before we get there, did Judge Shin tell the jury that I had made a finding?
He did not.
Okay.
Nope. And from the jury's point of view, they had to be wondering what was going on. Presumably, the judge had a copy of the grand jury transcripts. The defense counsel presumably had it. Prosecutor obviously had it. But, and they were referencing some documents, but the jury was never told what that was. There was a mention of grand jury a couple of times, and you could, make a presumption that they were reading from, but they weren't clearly, they really didn't understand what that meant, what was coming in.
So you'd say that, there's two steps. I think there's a lot in that last point that you're making. The first point about what the jury should be told and what they shouldn't be told. And I think you're referencing when the judge, outside the presence of the jury, makes that preliminary determination of fact upon which admissibility depends, determination that this is a feigned memory. Okay, that's fine. The judge makes that determination, but you don't want to tell the jury, well, I just decided that he's feigning a lack of memory.
Right.
So you can't say that, but
Right.
you want to explain to the jury what the grand jury minutes are and that they can consider those should they credit them for their truth.
And they can draw no conclusion at all as to why this is happening with respect to this particular witness. Now, if the witness is somewhat cooperative, perhaps that witness, he or she, could then simply read from it. But if the witness is totally uncooperative, outside the presence of the jury, that witness can be excused and someone else can read it. And so the jury does not, some protection is put in place so that the jury does not draw any adverse inference about this particular witness. And so when the witness is called back for cross-examination, now defense counsel, at least has got something to work with. In this case, defense counsel had nothing to work with.
Counsel, since credibility is such a big factor in trials, what is the legal theory behind behind protecting the jury so much from making evaluations of these witnesses like that?
Well, in this particular case, Your Honor, 40 pages of those leading questions came in, which represented a good deal of grand jury testimony from 3 witnesses, particularly Antonio Silva. That was the most damning. Whether or not he was being truthful at the grand jury or not is a question of credibility. Mm-hmm. And defense counsel should have had an opportunity to stand up without any prejudgment done by this jury of this grand jury testimony that then came in, at least as a fair shot of doing some sort of cross-examination to call into question portions of that grand jury testimony, to cross-examine what has come in factually pursuant to the day scenario standard. That did not happen here, and respectfully, that could not happen given what happened here. If you look at the cross-examination that was actually done, the first witness had, Daniela Timas, very little cross-examination. Second witness wasn't even cross-examined at all. And the third witness, Silva, was not cross-examined about any of the damning stuff that came in that was included in those leading questions. So, in essence, what happened here, because of the approach that the prosecutor took, was to render a good deal of credibility to what those three witnesses, and particularly Silva, testified to at the grand jury. And this jury, at the end of those 40 pages of testimony, of leading questions, could come to one conclusion and one conclusion only. What they testified at the grand jury was not only truthful, but in this case, given the number of leading questions that were put in the way that the prosecutor did it in this case, the prosecutor believes it as well. That's the concern that happened in this particular case. And I respectfully suggest that's the quantum leap that the prosecutor has attempted to do here, and it's this court that has established the protocol for the day scenario standard that we use throughout the Commonwealth. And clearly, it's...
Can we turn to the transfer intent argument that you have? You said there wasn't enough evidence for the instruction.
Yes.
There was a question by the jury, and the judge gave a transfer intent instruction.
Put this into context. The second day of deliberations, jury comes back with a question about deliberate premeditation. The question is put, according to Commonwealth v. Taylor, a group instruction is then given over objections. And I argue in my brief and in my reply brief that there was not the predicate factual foundation to support that giving of that group instruction. I want to make one correction here, and I apologize to the court for this. In getting ready for today's oral argument, I did note at volume 5 of the transcript, pages 46 and 47, Antonio Silva was posed a question about who was on the porch. Obviously, this particular argument is premised on the fact that you're going to allow or sanction the introduction of all those questions for substantive purposes. Other than anything that came in through those leading questions, there's nothing that says that there was a group on the porch. But at page 47 of volume 5, he was asked a question. Who else was on the porch when you got there? You responded, according to the prosecutor, Fafa, Lobo, this guy named Swagger, and there were more people who were there, but I don't know who they were. That should have been recognized by me when I did my reply brief. It was not, and I apologize to the court for it. But notwithstanding that fact, we do know that Fausto left. There was evidence that Fausto left. There was evidence that the girls left. There was evidence that Silva left. And so our reasonable inference would be that there were other people on the porch in addition to Lobo, who was fatally shot. The one thing I would say, and this kind of merges into the 278-33 aspects of this case, we do know that Silva did say, after the shooting, he looked over and he saw everybody or everyone going back to the porch. And I make this argument in my reply brief. That's a suggestion that there's no one else on the porch. Everyone did after the shooting. But the Taylor case, and this merges into my 278-33 aspects. If you look at the facts in Taylor, they are so much closer to an intentional killing than the facts in this case. In Taylor, you had the defendant had crashed a party. he had punched someone, a guest. He had been asked to leave. He came back. One of the people at the party that was still there challenged him that give me my money back. There was a concern about $50 being stolen. And in that case, the defendant in Taylor said, "I'm down here, come and get it." And by the way, when he had left, he had told other people, and this was evidence, "I'm going to do what had to be done," and he went back. Then, at the front door, the people inside the party were attempting to close the door, keep him out, and at that point, Taylor is seen taking a gun out of his waist, aiming it directly at the victim, and shooting. That there in Taylor resulted in the group instruction that was affirmed on appeal. In this particular case, assuming that there was more than one person on the porch at the time, taking the evidence in the light most favorable to the Commonwealth on this particular point, what you've got is 2-3 people in the dark on the porch, 2 people, for the sake of argument, we'll say the defendant, fire toward the porch from a distance, not up on side of the porch, and then the evidence is that they left. And so that, I would respectfully suggest, there are manslaughter convictions that have been affirmed on facts similar to that, and this is much more akin to a second-degree situation at the most. And so, unless there are any other questions, I'll submit on my brief, and I thank the court for its consideration.
All right, thank you. Mr. Schulis?
Good morning, Chief Justice Gantz, Justices of the Supreme Judicial Court, Laurie Schulis for the Commonwealth. Justices, I'd like to be clear that this is not a leading question type of case, nor is it a vouching case. This is a situation, it's a classic admissibility of the substance of a witness's grand jury testimony once a finding of feigned memory loss has been made. In this case, the defendant concedes that they're not challenging that the finding of feigned memory loss was proper, and I think justices can read from the transcripts that it was proper in this case. So once that is established, and the day scenario protocol has been met, that the grand jury testimony comes in substantively, then what happened here was typical in what happens in most trials, is that the grand jury testimony comes in. So in a similar situation in scenario, in that situation, the prosecutor read questions to the witness from the grand jury testimony and asked the witness to read the answers. So it was very similar to what happened here. I think the justices have suggested, and the case laws we have seen, is where the grand jury transcripts are actually read completely to the jury, or the grand jury transcripts are provided to the jury in a redacted form. I would suggest to this court that's a difference without a distinction, or distinctions without a difference, because the end result is the questions are read to the jury because it gives context to the answers. Without the questions, there is no answer, or there's no context for the jury. And the suggestion that the jury was unaware of what was happening here, that they were being read from grand jury testimony, is just simply false. Each time the prosecutor read the grand jury questions to each witness, he prefaced it by saying, you testified before the grand jury, and you were asked this at the grand jury, and your answer was this. Do you recall? The answer I don't recall is the whole purpose behind the feigned memory loss finding, the whole purpose why the doctrine was established and why it has been upheld since then. It's for the purpose of letting the jury know that that witness is not recalling their prior testimony, could have been given 2 or 3 years prior, and specifically in this case, specific to Mr. Silva, he testified, I've been shot 3 times since my grand jury testimony, and I smoked up a lot. I don't recall my grand jury testimony. So that goes to your question, Justice Cipher, regarding the credibility determination that this jury had to make. The jury didn't have to believe that Mr. Silva was lying at trial, and that what they believed is that he didn't recall his prior testimony. That, by the way, was given under oath to the grand jury. When the judge makes the finding of feigned memory loss, all that testimony comes in, and the jury now knows that they can't recall the prior testimony. Not that they're lying, or not that they were more believable then than now, but that they cannot recall.
Hold on for a minute. Are you saying that the scenario day procedure allows the grand jury minutes to come in as substantive evidence if the witness does not recall the events at trial because their memory's exhausted or they've lost a memory? Because that's wrong.
I'm
You
not
know
s-
that's wrong, right?
I understand that's wrong, that's not what I'm suggesting. I'm simply responding to the point that my brother made that, that for some reason the prosecutor was vouching for this witness's credibility and that the jury had no idea that they were hearing from grand jury testimony. I'm simply responding to that. And to that point, I would say the jury was well aware that they were being read to from grand jury testimony, and they didn't have to make that credibility assessment, especially in Mr. Silva's case, because he said he couldn't recall because of things that happened to him since. So once we have the finding of feigned memory loss, which we know is unchallenged here, that prior grand jury testimony comes in substantively. And I would suggest to this court that it came in properly. The procedure that the prosecutor used was proper. The questions are going to come in because they give context to the answers. The jury is later instructed that the questions phrased, no matter how artfully phrased, are not evidence, and the jury's well aware of this. So what the jury's aware of is they're being read questions and answers from grand jury testimony. And in putting aside the fact that the defendant is not challenging the finding of feigned memory loss, when we look at the grand jury testimony that was read here, none of that is leading questions. Those were, what happened when you got to the scene, where were you, stuff like that. They weren't really leading those witnesses to an answer. They were open-ended questions and follow-up questions in the grand jury context. So my point is this: there really is no challenge to the feigned memory loss finding. There cannot be one here, which is why the defense doesn't challenge it. Once Judge Chin made that finding, the procedure the prosecutor used was proper. The judge actually looked at it, and then in his determination on the abuse of discretion standard, allowed the questions and answers to come in. And my brother concedes there's no case from this court that tells us the proper procedure. My suggestion is, as in every other piece of evidence that goes into a jury, it is up to the judge's discretion on how that evidence comes in. And this court has left that determination up to the trial judge. And unless there's some sort of error or deficiency, then that procedure should be upheld. And the trial judge should be allowed to watch the jury, watch how the evidence comes in, watch the prosecutor, and be able to determine whether or not it was proper. And here he looked at it, and he said it was proper, and there are no cases that say what he did was improper. In fact, it's completely proper. The prosecutor read. You recall being at the grand jury. You recall being asked this question. You were asked this question, this was your answer. Do you recall that?
What about Mr. Roseal's argument that the way it was done made it impossible for the defense attorney to cross-examine those witnesses?
I completely disagree with my brother. The prosecutor alerted everybody in the courtroom, the judge who had copies of the grand jury transcripts, as well as the defense, line and page number. The defense could question the witnesses as to any of those statements that they made before the grand jury, and there was ample opportunity for cross-examination had defense wanted to do it. I suggest that he didn't question those witnesses about the grand jury testimony because it wouldn't be helpful to the defense to question them further. So there was an opportunity for meaningful cross-examination. The defense was alerted specifically to line and page numbers that the prosecutor was reading from, and there was always the opportunity to cross on those if the defense chose to. So the day scenario protocol is met. There's given an opportunity for meaningful cross-examination. In this case, he didn't want to meaningfully cross-examine because there really wasn't much to cross-examine on, especially when you have all three witnesses corroborating each other. And I would like to add as well, not only did the witnesses corroborate each other, the defendant's own interview corroborated much of the testimony. He corroborates that he's there, that he's in the back seat, that there's 5 to 6 dudes on the porch, that he goes and talks to all 3 girls, that his nickname is Zico. The defendant himself puts himself there in the back seat talking to the girls with the group on the porch. So this grand jury testimony did not stand alone. And we also had another witness testify, Mr. Carrera, and that's significant. The judge took a look at his grand jury testimony and didn't allow it in because he didn't have an interpreter at the grand jury proceedings, and that's significant because it demonstrates to this court that Judge Chin was familiar with the protocol under Scenario Day and didn't just let everything in. He weighed it properly and said, Mr. Carrera did not have an interpreter at the grand jury, so we're not going to allow that testimony in. But nonetheless, testimony from Mr. Carrera came in. And what did,
I'm not sure, to the extent I understand the appellant's argument, though, and maybe I don't, but I think what he's saying is that the prosecutor reads the question and then the answer, and that's actually the question, and then says, do you remember? And that's the answer. And the answer has no probative value. And I think the second part of his argument is, if I understand it, that sure, the prosecutor, the defense attorney can absolutely probe how good a memory the witness has as to the facts as that witness is presenting them. But the way that this question and answer was done was like asking 40 times in a row. You don't remember that. So it's an asked and answered question, however many times as a grand jury question posed. So it's not that it wouldn't have been fine just to read the question and the answer in. He's saying, I don't know, I'm not sure that it's right, but what he's saying is that I think that this procedure was not the right way to do it.
and so, Your Honor, I would suggest to this court that it was proper. Do you recall that? Because the witness is on the stand and should give the witness an opportunity to say whether or not they recall their prior testimony that has been admitted. And so it's not as if the prosecutor is saying, that was true then when you said it, right? It's not true now. He's asking, do you recall making that statement? The witness is simply saying, I do not recall. I don't believe there is any case that I have found that suggests that that is improper. And certainly Judge Chin did take a look at this and he was comfortable with it to present and comfortable that it could be presented that way to the jury. If Your Honor is suggesting that just reading the questions and answers themselves and leaving it out there for the next question and answer, I think the way that the prosecutor did it here was respectful to that witness. This is the question and this was your answer. Do you recall that? This was your next question. This was your next answer. Do you recall that? It was a respectful way to get it to the jury from the witness without badgering, let's say, the witness, for lack of a better word. So I would suggest that it was proper. The procedure here was proper. Do you recall it? Give the witness an opportunity to say whether or not he or she recalled it.
Do we have the grand jury transcripts as part of our record?
They're not part of the record here, Your Honor. The substance that came in, at one point the judge did ask for a grand jury transcript for one of the witnesses and he was provided with them. I could certainly get that for this court, but it's not part of the record here that came up.
I think we probably should compare the actual grand jury transcripts with the questions asked to make sure that there was nothing unfair.
Well, again, Your Honor, there is no argument that it was unfair, nor was there, and the prosecutor did specifically point to the line in question number, so any suggestion that it was unfair has not been raised. There was no objection at trial to any of the statements coming in, and that they were incorrect. So,
But there was an objection to the form in which it was
just the
asked.
form, but not the substance, and I don't think the defense is objecting now. There's been no suggestion that it was improper or inaccurate. And as the judge himself had copies of the grand jury transcripts, and he could read along with it, and he was administering the trial, he was administering the voir dires, and he could see for himself whether or not the prosecutor was being accurate.
Now, am I correct that there was much corroboration for the fact that there was a verbal dispute between the defendant in the green van or whatever it was, and Fausto
Correct.
on the street, roughly, 32 minutes to an hour before the shooting?
Correct.
But am I also correct that in terms of identifying the defendant as the shooter, it comes down to the grand jury testimony of Silva, who saw the defendant running with the gun after the shooting, and the Red Sox hat?
You're correct, Your Honor. In addition, Silva also identified the defendant through a photo array.
As the person he saw running.
As the person he saw running.
Right, but basically, he was the only percipient witness who placed the defendant at the shooting with a gun.
With a gun in his hand, as well as the hat with the defendant's DNA on it that was found in the street. So you're correct. He is the witness who saw the defendant run away. I would like to say that there were more witnesses who saw him with the gun, but it was Mr. Silva who saw him run away. Mr.
We
Silva
don't-
identified him.
We don't have their testimony.
We don't.
So, now, speaking of the porch, I know there was substantial testimony, including from Silva, that there were many people on the porch when the green car was there. I guess we had Silva, Fausto, the victim, and Swagger. But do we have any testimony that 30 minutes to an hour later, when the shooting occurred, there was anybody other than the victim on the porch?
So we don't have any testimony. What we do have is the video, and I admit it's grainy, but what you can see is people milling about when the defendant and his companion come back in the dark. There's people milling about. And you also, Your Honor, if you're referring to the instruction, so when we talk about the transferred intent instruction, Judge Chin was correct. So what he said is this is not a transferred intent case, and the Commonwealth didn't ask for a transferred intent. And the reason is this. When the defendant informed his intent to kill, it was 30 minutes prior when he said, "I'm coming back." The people on the porch at that time, it is uncontroverted, were Mr. Lobo, the decedent, Swagger, Fausto, and Mr. Silva are all on the porch, among others. There's other people there as well. The defendant says he's coming back. He forms his intent. He leaves, comes back with a gun, which suffices to establish his intent, that he went and got a gun in the meantime. Comes back with the gun and goes to the very porch and starts shooting. We know, obviously, Mr. Lobo's standing there, and his intent was to kill anybody who's on that porch, any member of the group, which is the Commonwealth's theory of the case. What we do know is when Mr. Silva came running up and chasing the defendant's shooting at him. The defendant didn't shoot one shot. There was 8 shots heard. He's shooting at anybody on that porch, anybody who's a member of that group, and he kills Mr. Lobo, who was a member of the group who was on the porch originally. So when Judge Chin determined that the Taylor instruction under the shooting into a crowd was appropriate and stated that the facts supported it, he was correct. This was not a transferred intent case. No one was mistakenly shot. The defendant intended to shoot a member of the group, and he did.
Okay, let's assume, for the sake of argument, that when we look at the evidence and look at the video, we will say that there was evidence that there was a crowd on the porch 30 minutes to an hour before, but we can't discern anybody who said that there was anybody on the porch at the time of the shooting. 8 shots were fired, but I guess nobody else was injured except for the victim who was killed, and perhaps the video is not as clear as you do. So let's imagine that we say there was not evidence that supported a finding that there was a group on the porch. What's the consequence, if any?
There is no consequence because there is no requirement under this instruction. The instruction reads, as long as the defendant intended to kill a member of the group and did kill a member of that group, and Mr. Lobo was a member of that group, then the instruction is appropriate and it supports the conviction. So Mr. Lobo is a member of the group originally. We know that. He's ultimately killed. We know that.
We say member of the group. I mean, I gather, you know the record 1,000 times better than I do, but I gather these folks are on the porch.
Correct. They're together with Fausto. They are a group.
So walks off the porch and is at the car with them. Is that right?
Correct.
So the only dispute appears to be between Fausto and the defendant.
Fausto goes back up to the group. So Fausto is with Mr. Lobo, Mr. Swagger, and Mr. Silva on the porch. Then Fausto comes down, he goes back up, and the defendant says, "I'll be back." So the reasonable inference in the light most favorable to the Commonwealth was that when the defendant said he'll be back, and he came back and shot on the porch, he was shooting at members of that group, of which Lobo was a member.
But I don't understand why he would be teed off at the group if the only person who he was talking to was Fausto. Why would he necessarily be angry at the group when it was only Fausto who was at the car and said something to him which teed him off?
So the question is not whether or not the defendant was mad at the group. The question is whether or not the defendant intended to kill a member of that group when he came back, and he did. He said he was coming back. He came back and shot at the porch. Mr. Lobo's on the porch. And we don't know whether or not there were any there was a whole group on that porch afterwards, or what? You're correct, when we do not have that evidence, but the reasonable inference, when the defendant came back, and you can see on the video, when he's walking towards that porch and he extends his hand with the gun, he's shooting, he shoots 8 times, or 8 bullets, and he's, spraying onto the porch. So the reasonable inference is it's more than just Mr. Lobo on the porch. There's more people gathered on the porch, and you can see people walking around on the video. So the reasonable inference is that there's still people on the porch, that the defendant goes there to shoot at Mr. Lobo or any member of the group, and he does. If this court were to find that a transferred intent instruction was appropriate, in this case, there could be an argument that a transferred intent instruction was appropriate, in which case the defendant shot Mr. Lobo when he came back. Either way, the instruction was appropriate because Mr. Lobo's a member of the group. The defendant formed his intent 30 minutes prior, came back and shot a member of the group. So the instruction is appropriate. The supplemental instruction is appropriate.
Okay. Is there anything in the record to indicate whether the victim looks like Fausto at all?
There's nothing in the evidence to suggest that, Your Honor, but I think under the theory of the case, and this is what the prosecutor stated in his closing and at the charging conference, the theory of the case was the defendant came back and he was angry. He came back with a gun and he came back to shoot at that group, and he did it. That was the Commonwealth's theory of the case.
Right, I understand. And do we know how far away he was when he was shooting? How far away from the porch?
From watching the video, it's hard to tell where the porch begins and where the street ends, but suggesting it was a few feet away. The medical examiner said that Mr. Lobo was shot from more than 2 feet away. So there are photos that were in evidence. If Your Honor would like, I could have them sent up, but I would suggest probably no more than 5 or 10 feet away. But I'm not 100% sure. I can't
So
be 100%
8 shots fired from that proximity and only one?
That, Your Honor, to be truthful, that's a guess. I'm not really sure how far away it is, but it is night out and it is raining, and he shoots into the porch where the people are gathered there and shoots Mr. Lobo, fatally wounding him.
Okay.
Thank you, Your Honors.